All right. So, welcome back. It's been a few days, but I've got something good for you today. Um, as I said in my post, I am going to be covering today Know Your Rights, How to Publicly Protest in Private Events. So, I have four propositions for this video that I want to convince you all of because they are your legal rights. These are First Amendment rights you can apply in your day to day whenever you go protest. As you can see, I've got some new gear, new camera, I've got a light. Hopefully it looks better, a little enjoyable, a little more enjoyable. But my first proposition is that parks, streets, and sidewalks are highly protected in terms of freedom of speech. So if you're here, you have ground to stand on, literally. So we get that idea from Hague v. CIO, and uh, that was the Supreme Court case that established how important public parks, streets, and sidewalks are for the First Amendment protected activities. So we can see the effects of the case in the three examples I have from circuit courts, right? So the first example is Bays v. City of Fairborn. In this case, we had two Christian evangelists who attended a corn festival in a actual corn, by the way, sweet corn festival in a public city park. So they held signs and handed out literature like many of us abolitionists do, but they were threatened with arrest and they left because they were breaking a festival policy saying no solicitation or distribution outside rented booths. So afterwards, they sued because they were threatened with arrest, and the court held that government enforcement of this policy warranted a First Amendment audit. And so they determined that because the evangelists were in a public park, that even though a separate event was happening, so the park was permitted, they had a First Amendment right to be there because it was a public park. In this other circuit case, we have Sistrunk v. City of Strongsville. And this case I want to bring to your attention because it's very important you understand that the ground you stand on is only parks, streets, and sidewalks. This case comes from a woman who wore a political campaign button to an opposing political campaign rally. And the organizers had her removed after she refused to remove it. And after suing, the courts held against her because the rally was not held in a traditional public forum, but rather a limited public forum. I'm sure you're wondering, what are these public forums I'm talking about? Well, they come from the Perry v. Perry Supreme Court case. Perry Education Association v. Perry Local Education or Local Educators Association, I know, was the Supreme Court state case that established the public forum doctrine. And this doctrine is a tool used to determine the constitutionality of free speech restrictions implemented on government property. So it found that there are three categories of forums. There's the non-public forum, which is government property that's not by tradition or design a forum for public communication. Limited public forum, so that's government property that the state intentionally opened for public discourse for certain topics. So if you look back in that case of the woman with a button going to a political rally, that was a limited public forum. They opened that for public discourse, and therefore the people that they permitted it to had more rights in limiting free speech. And then there's the traditional public forum. So that's what we're here to talk about. This consists of streets, parks, and sidewalks, which have immemorially been held in trust for public use in assembly. And so that's where our right to assemble is most protected, and why private events in traditional public forums cannot legally stop us from attending in the form of protest. I hope that's sufficient to convince you of my first proposition. Parks, streets, and sidewalks are highly protected in terms of freedom of speech. So if you are here, you have the ground to stand on. My second proposition is that reasonable content neutral restrictions on location, safety, congestion, or interference may be allowed. the government they do still have some rights to, I guess we'll say, inhibit or prohibit free speech, but it has to be reasonable, content neutral, and it needs to be dependent on time, place, and manner. Ward v. Rock Against Racism was another Supreme Court case that held that the only restrictions can be imposed on constitutionally free speech are to be on concerns of time, place, and manner. So this is a Supreme Court case that established this, and we can apply it in some other circuit courts. I think one of these is Supreme Court as well, and we can just see it in action. So, Police Department of Chicago v. Mosley. It held that the government cannot permit speech on one subject while prohibiting speech on another. So you'll see this in a lot of Abolitionist Risings videos, where they will have a sign on a campus and someone comes up and they say, hey, you can't be here, we have a sign policy. And then you look down the road and then there's like a Mormon or a JW sign that's left unattended and is bigger than whatever qualifications. So that would be an example of not content neutral restrictions. And oftentimes you'll see them say, well, you're congesting the space, and that is correct. So that is a concern of place and manner. Is like, hey, you are congesting, but it is not reasonable, because oftentimes they'll say that and then you're like, well, I'm standing on a street corner, people can walk around me. So that you could fight against. You got to know your rights, because oftentimes they will, and when they do, they'll try to abuse it and confuse you. And that's an example of them trying to confuse you. It's like, yeah, you're in a traditional public forum, but there's still certain things that you have to follow. And that's one of them. Another example was Starksville v. City of Philadelphia. A protester was in a traditional public forum, but they were at a Pride festival, I believe. But they were being disruptive and disobedient. So they were disrupting and not allowing people to move, and they were causing a ruckus, we'll say, and then they were disobeying lawful orders. So I don't know about the lawful orders being lawful, but it was probably built off of the presupposition that they thought that they were within their rights. So since they were outside of their rights, being disruptive, the order that they thought was unlawful was actually lawful, and so they were hit for both. So that's why you got to be careful. You got to know your rights. It's part of this video, is you can't be disruptive. So that's like time, place, manner. The time restriction is like for people who are being loud and obnoxious, and it's midnight. Last example I have for this is Bays v. City of Fairborn. So this is another circuit court case. So it held that restriction in a traditional public forum, the restriction in this case in the traditional public forum was not narrowly tailored, nor served a significant government interest, and was unconstitutional. So in this example, it was another festival, and people were, I think, holding signs or they were leafletting, and they were next to the festival's like booths where they were selling stuff, and they had a policy that you can't solicit at booths, and they were employing this policy to get this person they disagreed with outside of the festival, and they succeeded, but then when they were sued for it, they lost, because it was unconstitutional that they were just applying this random policy. I would say it wasn't content neutral restriction, but it also wasn't reasonable, so it wasn't tailored specifically enough. So if you see something, like, it's always best to like listen to authorities and to respect authorities, except for whenever they're impeding on your rights specifically. It's like, I do this. I went to a Pride festival with a sign, and the officers were like, this is a ticketed event, you're not allowed to go in. And so I just pulled up a ticket on my phone. I said, hey, I got this ticket for free, I can go in now, right? And they were just like, please don't, we don't want you to get hurt. I said, okay, but I want you to see the hypocrisy that you're pointing out. You just cited something to me that was false. Like, you're saying all these people had tickets. Well, the tickets were free, so if they did, like, I'll give them the benefit of the doubt. They all had tickets. I have a ticket too, and now you're just like being deceptive. So I pointed it out to him, but I was also respected him because I also didn't want to get arrested for bad behavior or something. I know that there's like the heckler's veto that doesn't work. You can't get kicked out for other people's reactions to you, But still, I wasn't going to risk it. I'm too young for that. I'm not going to go through it. But my next proposition is that restrictions based on the speaker's viewpoint are generally unconstitutional. So this goes back to the second one where it said it needs to be content neutral, but this is a little more specific. The court cases I have to support this are Rosenberger v. Rector and Visitors of the University of Virginia. And this held that the government may not favor one side of debate over another. This would be, for example, protesters, counter protesters. Oftentimes you'll see abolitionists go to pro-life events, and whenever you do, you are labeled a counter protester to the protest. So government, we'll say like authorities like police, they don't have to, but generally they will set up like a dividing line, say counter protesters here, protesters here. But what they can't do is they can't favor the protesters over the counter protesters. So they can't be like, okay, the pro-life group gets this big venue, this whole plaza, and the counter protesters, we will designate you this sidewalk over here. That's not how it works. It has to be content neutral. And Mittal v. Tam is I don't believe it's a Supreme Court case. It's a court case that held that the government may not suppress speech because officials don't like it. And this is what we have to fight against. As abolitionists, we will get pushback from officials both in the government and in the organization that we're attending. And we cannot have our speech suppressed because they don't like it. And that's what they want to do. They want to suppress speech that they don't like. And it's unconstitutional. My fourth proposition is that the government generally cannot prohibit peaceful sign holding or leafletting simply because the speech disagrees with the event. So this seems simple, but it's not that obvious. It's also where I have the strongest case for us, is that when we go to a Pride Festival and go into the Pride Festival, or whenever Russell goes to the craft fairs, or the Renaissance fairs where he dresses up as a knight, or even doesn't dress up as a knight and just goes in street clothes, the government can't prohibit us from going there just because the speech disagrees with the event or the event organizers. You can even go to a pro-life event and you are allowed to be there. The same with pro-choice events. I've seen Heritage Restored, that YouTube channel. They've gone to a ice cream shop that was doing 50% of sales go to abortion clinics or something. It was horrible, it was disgusting, and they made sure that they knew about it. Heritage Restored is an intense group. But anyways, the court cases I have for this are Ward v. Rock Against Racism again. So the only restrictions can be imposed on constitutionally free speech are to be concerns of time, place, and manner. So an event doesn't play any role in that. And this is the big one. McMahon versus City of Panama City Beach. So this is a circuit court, so it's not a Supreme Court decision, but it is the exact thing that we're doing. And that's why this is the entire premise of this video, is this court case, and that we can replicate it if need be, and it is built off of the First Amendment, not off state laws. So though it is a circuit court case and not a Supreme Court case, it is built off the First Amendment and not off Florida state law, because this is from Florida. What it held was that despite the exclusive use permit, so that's the stuff that you will see and that you'll get kicked off for, and that I think we saw at the Alamo, is the park remained a traditional public forum despite the permit, and state action was taken to enforce the organizers' wishes to remove McMahon. So this falls under a First Amendment right violation, since a proper time, place, or manner violation or restriction was not set to prohibit free speech in a traditional public forum. It was just another person's opinion. So the stuff I said on Proposition 3 and Proposition 2 were what was being applied here, is they were trying to restrict his speech because they disagreed with him. What it specifically was a Christian evangelist at a motorcycle rally, and he was leafletting, and it was an exclusive use permit along a street So this is stuff you'd see for parades. This is stuff that you would see for festivals. Is a organizer, a private organizer, takes an exclusive use permit and permits a street, and then they think that they have private property rights over this permit, over this land because of their permit. And so what what the court held was that the exclusive use permit did not transform the land outside of being a traditional public forum. They said, no, this is still a traditional public forum. And what that means is that the state action that was taken to enforce the organizers' wishes to remove McMahon falls under a First Amendment right violation. I'm just running through it again because it needs to be so clear that this is what we're doing and this is what happened to this man. There was no proper time, place, or manner restriction. It was just the opinion of an official. And McMahon sued and won. And that's what we can do, is we can go into private events and we can protest with signs and leaflets. We just have to do it peacefully. So that's the manner. We have to be beyond reproof. We can't be caught on a time, place, or manner restriction. So you have to be peaceful. You have to be out of people's way. So that's a place restriction, is that you can't be causing congestion or out in the road. Don't do that. And you have to do it like during the event. That one seems obvious, but it's just important that we do this properly. Now that we're over that, go and do abolition work. You have so many rights as long as you are in a park, a street, or a sidewalk. I went and looked through all of the ordinances in my city. I didn't have to do that. I could just look at state and federal law. So what I want you to do to apply this in your life, in your protests, when you go out holding a sign, go out talking to people, go out leafletting, is figure out where you're going. Is it a traditional public forum? The easiest way you can figure this out is if it's a public park, city owned, street, or sidewalk. Make sure it's not privately owned. In Fort Worth, there's Sundance Square Plaza that's privately owned but publicly used. They cut a deal with the government or something, but it is privately owned. So you can get trespassed legally from Sundance Square. So make sure you know where you're going and what it is. Publicly owned parks, streets, and sidewalks. Understand that there are 3 restrictions that you have to adhere to and none else. You can be trespassed or arrested or moved if it is a time, place, and manner restriction only. Nothing about opinions in there, nothing about permits or organizers. We've just looked at a ton of court cases that say that permits don't mean anything in the face of your right to free speech. So be beyond reproof and go and protest. Protest for the life of the unborn, like I do, and like so many other abolitionists do, and do it for God. Do it in Jesus' name. That is what I beseech you to do with this information now. Thank you guys for watching, for listening, and just dealing with looking at me. I know with the high-res camera, like, it's unsettling because you're going to be seeing a lot of this for this video. Good luck with the work that you do. Do it all for God. All glory to God, and I thank Him for everything that He's granted me, everything that I can do. Thank you guys.